Good afternoon, everyone. We're going to get started. Good afternoon to those of you here in Washington, D.C., and good morning to those of you on the telephone who are on other coasts. We have a wonderful crowd here in Venables D.C. offices for our program today entitled Exempt or Non-Exempt, the 10 Most Common Employee Classification Pitfalls Faced by Nonprofits. My name is Jeff Tenenbaum, Chair of the Nonprofit Organizations Group here at the Venable Law Firm. We have a very nice crowd who joined us here for lunch in D.C., about 75 people, and have over 200 participating by phone across the country today. And it's not surprising because this is a topic that in our practice and certainly in speaking presentations and in articles and everything else that we do as attorneys is extremely important, extremely popular, extremely confusing, and always seems to draw a great crowd and generate a lot of questions. I have no doubt that today's program is going to be no exception. Of course, that also means that we have a challenge in 90 minutes to try to get through quite a bit of important material and save plenty of time for your questions. So I will ask in advance, knowing that this topic generates probably as many questions, if not more, than any other topic that we do programs on, to try to keep your questions concise, not too specific. If you want something that's really specific, come up afterward and ask us, or reach out to us after the program by phone or by email or in person. But for purposes of today's program, we really want to keep it moving, cover a lot of material, so try to keep your questions as concise as possible. For those of you who have joined us before, and I know many of you have, this program is part of a monthly series on nonprofit legal issues that we cover every month here at Venable, sometimes even 2 a month. We've been doing these for close to 2 years now, trying to cover a wide array of different legal topics that nonprofit organizations face and that we deal with in advising nonprofits. Very much looking forward to today's topics. We have 2 terrific speakers with us today, and actually really pleased because we have 2 speakers for the first time here who are actually not from the D.C. or Baltimore offices of Venable, but are representing our New York City and our Los Angeles offices here today. And of course, these are both lawyers who counsel our clients who are based in the New York area and in California and related areas. To my immediate right is Dan Seamus. To his right is Nick Ryder. Both Dan and Nick are terrific lawyers, extremely knowledgeable in this area, extremely practical in advising our clients on these issues and others. And they also really understand nonprofit organizations and what makes nonprofits unique because they do so much work with our nonprofit clients. And I think you're going to benefit, I know you're going to benefit quite extensively from what they have to say today. Full bios for Dan and Nick are in your handout materials. Also in your handout materials, you have a copy of the pretty extensive PowerPoint presentation from today. As you might expect, we're not going to be able to cover everything in that PowerPoint in the same detail that it's in there. We're going to skim over some of it and focus on the things that I think are a bit more interesting and going to generate the most questions. In addition, in the back part of the handout, for those of you who are here in the room, you'll find a collection of quite a few articles and alerts that we've written on employment-related topics that are relevant to today's presentation. I would encourage you to take a look at those at your convenience. For those of you on the telephone, and all of you, in fact, will get an email tomorrow that will contain a link to the PowerPoint presentation, all the supplemental handout materials, and of course, as always, a link to the recording of today's program. We record all of these monthly seminars and webinars. They're available on our website. Feel free to share those recordings. It also has a streaming PowerPoint with colleagues and others who you think might benefit from those. Preview of our upcoming programs. We have 2 scheduled so far for 2013. Next month on February 12th, we're doing a program entitled The Top 10 Federal Grant and Contract Pitfalls for Nonprofits. An attorney here from our government contracts practice who works extensively with our nonprofit clients in the federal grant and contract areas, and a very experienced head of grants and contracts for one of our clients with whom we do a lot of work in this area. I think you're going to benefit quite a bit from that program. I know we've already gotten a lot of interest in that program, so if you receive any federal grants or contracts or think you might in the future, it's a program I encourage you to attend. And then on March 13th, our program will be entitled Preparing an Online Social Media Policy, the Top 10 Legal Considerations for Your Nonprofit, led by 2 of our star attorneys who do quite a bit of work in this area and are terrific speakers as well. So 2 really good programs. You always get email invitations for future programs. In terms of questions, for those of you here in the room, we do encourage you to ask questions throughout the program. Raise your hands. I'll call on you as appropriate. I might, at certain times, not calling you right away and get back to you as we let our speakers finish particular thoughts. As I said earlier, try to keep your questions as brief and concise as possible. There may also be times where we know we're going to cover material later in the program, so I'm going to ask you to hold your questions. And I apologize in advance if I have to cut some of you off in terms of not getting to all of the questions at the time, and we'll try to leave some time at the end as well. And our speakers will, of course, stay around after the program. For those of you on the telephone, on the webinar, you need to use the chat feature on the webinar software. Those questions will come to me at the laptop in the front of the room, and I will pose those questions to our speakers at the appropriate times or answer them directly for you myself. So with that, one more housekeeping matter. I want to welcome back Jamie Fitzsimons, our wonderful marketing assistant who does a terrific job in organizing these programs. She's back from maternity leave just a few days now, so we're welcome to have her back. And thank you to Pat Reed for all of your help in Jamie's absence. With that, I'm going to turn it over to Dan to get us started. Dan?
Thanks, Jeff, for those words, and thanks for everyone here for coming and everyone on the phone. And today we're going to talk about the exemption question. And for nonprofits, sometimes exemption is thought about in terms of the tax exemption, but this is a different kind of exemption, and it's very important because that is by far the single biggest question that we get from employers is, have I classified this employee correctly? And unfortunately, sometimes the question comes too late because it's after a lawsuit's been filed. It's after a claim has been made with the Department of Labor, and we look at the rules, and unfortunately, while some of the rules are kind of fuzzy, you can try to argue, well, he's exempt because, but some rules are black and white, and sometimes you're left telling a client you didn't pay him enough, so that's it, it's done. Bring out your checkbook. So it's a very important topic, and we're going to talk about today how to identify common misclassification errors and how to fix them, how to change them. Because if you learn, I mean, if you've done it wrong for a long time, it's not too late. Sometimes companies want to duck their head and hope nobody learns it because they're afraid if I change it, then it's going to be a big red flag. You know, you're waving your flag saying, look at me, I changed it, and so you feel you get in trouble. So if you don't do anything, people think that it's the best course, just leave things the way they are, don't rock the boat. But what happens is eventually someone's going to find out about it, and then you've got a lot of years of back wages to worry about. So we're going to try to help you guys think about, if you have them, how to fix them. And the topics we're going to cover today, we'll talk about the three most common exemptions: the professional, administrative, and executive. There's the issue of independent contractors. We're going to talk about. There's also commission salesperson, seasonal employees, computer professionals, and then we're going to try to spend a good bulk of time about the myths, what the title of this is, and that's the myths about exemption. Sometimes the reason that there are all these errors that employers are making is because they have these long settled myths. I don't know who started these rumors, but they're not true, and if you have them, we can help you. And then lastly, a really important thing is the importance of job descriptions. As we'll talk about, job descriptions are very important because it sets the bar for an employer as to what they expect this employee to be doing. And if you have a bad job description, or if you have not the correct job description, then that's Exhibit A in the misclassification case, because they say, look what my employer said I should be doing. And if it's on its face a problem, then it's going to be a big problem for you later. So very briefly, the overtime basics, it's 40 hours in a week is regular time. Anything beyond 40 hours in a week is time and a half, regular rate of pay. Now, I'm from California, so it's different in California. It's 8 hours. It's the 8-hour workday. It's even more difficult to comply with, so different states may have different rules. And again, the common exemptions we've talked about, we're going to talk about today. But at the bottom here, the thing to really remember about applying the main exemptions is the duties test and the salary test. Those are the two areas that you have to ask yourself, do they satisfy both? Because you can satisfy one, but if you don't satisfy the other, then your employee is not exempt, and they never were exempt, and you're going to owe all the wages that they're going to be entitled to. So you have to make sure that you satisfy both. So looking over the duties test, under the FLSA, the Fair Labor Standards Act, the question is, what is the employee's primary duty? And that's the real important test. It doesn't necessarily mean what they spend most of their time doing. It's not strictly a time test, like do they spend more than half their time doing certain duties. It's not just that, but it's the question of what's their primary duty. So that focuses on things like the relative importance of the exempt duties when compared to the other duties. So what is their focus of their job, the amount of time they spend, again, not the focus, but it is important. The relative freedom from supervision. So the fact that they're micromanaged a lot, that's a big issue. They're not going to let you micromanage an exempt employee. And finally, the wages paid to other employees for non-exempt work. If you're paying your exempt supervisor the same wages and he's doing the same things as his other employees, then it's probably not going to be an exempt person. Under the salary test, the basic rule is the threshold is, minimum threshold is $455 per week, or translated $23,000, $660 per year. That is the current threshold for the minimum. You have to pay them on a salary basis. That means that you can't vary them week to week. It has to be a guaranteed minimum threshold, or they're not salaried. And also you're not able to reduce or deduct their salary because of things like not enough work. So don't come today. You can't dock them because they weren't there. The question is if they are ready, willing, and able to work for a work week, and you work them any part of that work week, then they have to get their minimum base at least. And if they don't, and you start docking them for things like quality of work or quantity of work, then there's going to be then they're not going to pass the salary test.
Thanks, Dan. Good afternoon, everyone. Before we get to the common pitfalls for nonprofits, we're just going to try to quickly comb over some of the common exemptions that we see from the Fair Labor Standards Act. And the first one that we want to talk about is the executive exemption. And these are really your managers, your heads of department. As Dan was just mentioning, the first inquiry is whether they pass the primary duty test. And for the executive exemption, the primary duty for those employees needs to be the management of either the overall enterprise, or at a minimum it has to be a department within the enterprise. The second thing that an employee needs under the executive exemption is he or she needs to be regularly directing the work of at least 2 other subordinate employees. And last, the employee who's exempt under the executive exemption, they need to have the authority to hire and fire other employees, or alternatively, they can make recommendations for hiring and firing decisions. Now, one of the problems that nonprofits face with the executive exemption is a lot of nonprofits, they ask their employees to wear a lot of different hats at one time. So it can be difficult for nonprofits in particular to determine whether someone's primary duty is the management of the enterprise or a department within that enterprise. And so some of the things to look for is, does their job function, does it require leadership? Are they acting in a supervisory role? Do they have that independent discretion? Things like you can see on this list here, interviewing and selecting employees, making budgetary decisions. Conflict resolution is a big one. If an employee is responsible for resolving internal grievances by other employees, for disagreements between 2 or more employees, that's going to be a strong indicator that they're acting in that managerial role and that they're possibly exempt under the executive exemption. Now, the second requirement for the executive exemption that I mentioned is that they have to be regularly directing subordinate employees. And it has to be 2 full-time employees under their supervision or the equivalent thereof. And when I say under the equivalent thereof, it could be part-time employees, but then the weekly work hours for those part-time employees that are being supervised, it has to be at least 80 work hours in that week or more. And that last requirement for the executive exemption under the duty test is the authority to hire or fire employees. And that doesn't mean that if the employee in question isn't the final decision maker, that doesn't necessarily mean that they're non-exempt under this exemption. They can still be exempt if they merely make recommendations. But one of the things that a court or an agency like the Department of Labor is going to look into is how often those recommendations are heeded. How often are those recommendations about firing or hiring decisions, how often does management go along with the employee's suggestion? And finally, for the executive exemption, you always want to consider the salary test. And that's, as Dan pointed out earlier, that's $455 a week at a minimum and on a salary basis. Under the executive exemption, the employee cannot be paid on an hourly basis. And really, the salary test for the executive exemption is less of an issue because generally your managers of your departments are making more than the $455 per week. Dan's going to talk a little bit now about the administrative exemption.
Yeah, question here.
On the duty test for the executive exemption, does that individual have to meet all of those conditions or just one?
Yes.
If you could repeat the question.
Sorry, for our online listeners, the question was about whether under the executive exemption all three of those requirements need to be met. And the answer is yes. And generally they go hand in hand. Somebody whose primary duty is to manage a department generally is going to be at least making recommendations about hiring and firing decisions. And they're also generally going to have at least 2 employees under their supervision.
And Nick, we have a question from someone online. What about when it is a small nonprofit organization with only 2 employees? Is it possible for there to be an executive exemption?
Well, probably the better question there is whether they even need to be considered the Fair Labor Standards Act in that small environment.
Why don't you explain the kind of threshold applicability of the FLSA?
Well, and Dan, correct me if I'm wrong here, but the Fair Labor Standards Act, you still need to qualify as an employer, and for an entity as small as 2 employees.
I mean, it does happen. We don't see it that often,
yeah.
But once in a while, a lot of times small organizations like that are managed by a management company or some other kind of a for-profit company that manages. But sometimes there can be. We have seen, especially maybe not 2, but 3, 4, 5 employees. Any unique guidance about how the executive exemption would apply, or is it really kind of the same basic analysis, just in a smaller setting?
It would be the same basic analysis.
Yeah, I mean, I would say that with the 2 employees, if one is supervising the other, then it wouldn't be, the executive exemption would not apply. If somebody was supervising those 2 employees, then it would. But if it's one-on-one, it's not going to work.
Okay, thank you.
Okay, so turning to the administrative exemption, this is an often misunderstood one, and the basic, starting again with the duties test, the first one that you have to worry about is the main question is does the employee's primary duty, there's that word again, is the primary duty office or non-manual work, so not labor, not hard labor, and is that work directly related to the business operations, the management or business operations of the employer or its clients and customers. And what that basically means is, does the employee help the business run? Is it the production side of the business, or is it the administrative side of the business? So, and we'll talk a little bit about that a little bit later, but that's the core difference between administrative employees. They don't sell the products, but they help the business run so that it can sell the products. And then the second issue, and this is the overlying theme with a lot of these exemptions, is that their primary duty must require the exercise of discretion and independent judgment with respect to matters of significance, and that's an important qualifier. And so the question of whether the duties are directly related to the management or general business operations, this has to do with whether or not the duties are related to the running or servicing of the enterprise instead of the manufacturer, sales, or retail, and that's that dichotomy. Look at your employee and say, are they making the widgets, or are they allowing us to make the widgets? Are they doing things like, and the examples in this list are things like finance, auditing, budgeting, purchasing, advertising, recruiting, things like that, things that help the business run. And
as opposed to kind of being on the front lines of program service, delivering educational content, delivering membership services, carrying out federal grants and contracts, things like that.
Exactly. And the substantial importance issue is a key issue as well. It has to be substantially important to the management. It just can't be a piece of the management or the running of the business. The exercise of discretion and independent judgment, Nick touched upon that, and that has to do with the idea that the employee has choices to make, and the choices between A and B, and he's free from immediate direction or supervision. So even though he's not the final decision maker, the employee can make effective recommendations and basically has final say. Just like you can't terminate, like in any business, most people can't terminate an employee by themselves. They have to get HR involved. But the decision to terminate it often rests with the supervisor, who has to go through HR, and that type of discretion and that type of decision is an example of discretion and independent judgment. But lastly, merely following procedures is not sufficient. So if the employee has a playbook or a list of prescribed procedures that they have to follow every action they make, that's not going to be sufficient to qualify for the administrative exemption. They have to have some discretion, ability. You can look at their day. Usually I can find out in 5 minutes if the employee is exempt. And the basic question I ask is, do they have free reign to make decisions? Or are they being micromanaged? Are they being told what to do? If they've got some discretion and room, then there's a good chance they're exempt. And then finally, moving on to the matters of significance, this is just a list of things, factors that are involved. There have to be major assignments. They have to affect operations. The employee has to have the authority to implement the policies and the authority to deviate from the policies as well. It has to be able to commit the employer to significant financial matters, involvement in planning of long or short-term business objectives, and things like that. So these are all just factors. They don't have to all these factors don't have to be present, but these are all examples of ways, things that they'll look at to see if they qualify for the administrative exemption. Yes?
Regarding the commitment employers, does that mean they have authority to sign contracts, or
Sure. The commit, basically, it's very.
The question.
Sorry. All right. The question was that on the factor of commit the employer to significant financial matters, does that mean that they have to be able to actually sign the contract, write the check, things like that? And I would say no. They don't have to make the final decision, but it must be similar to the effective recommendations that we were talking about before. They have to basically have the say. Just because they have to run it by their boss doesn't mean that it's they don't have the power to commit. As long as they can make effective recommendations, then you'd be okay. And the last point, always don't forget the salary test, $455 per week, and be salaried.
Thanks, Dan.
And one point on the salary test, maybe when you guys want to flesh out a little bit more, the issue of how someone who is generally paid on a salaried basis, how that salary test can be defeated if pay is docked in certain circumstances. I know we've talked about this internally many times before, but when do you want to flesh that out a little bit and explain what that means?
That's actually in a few slides. We're going to be talking about that.
Perfect.
The next exemption we want to give a brief overview of is the professional exemption, and this really dovetails into two subsets of employees. Under the duty test for the professional exemption, the primary duty for that employee must be work which requires either knowledge of an advanced type or field science or learning that's generally and usually acquired through a prolonged course of study or instruction. Or alternatively, it's employees whose work requires some type of invention, imagination, or originality in what is a recognized field of artistic or creative endeavor. And the salary test still applies for the professional exemption. That is, employees earning at least $455 per week and on a salary basis, not paid hourly. And the two types of professional exemptions that are recognized by the Department of Labor and by courts are the learned professional exemption and the creative professional exemption. And first, for the learned professional exemption, we're talking about work that must require advanced knowledge that's intellectual in character, that requires, that typically involves independent discretion and judgment, and it can't be that routine mental or manual work. These are really employees who typically have gone to school or some other type of training for a longer period of time than other employees in order to obtain an advanced knowledge in a specialized area. These types of employees generally have some type of advanced degree, not necessarily a graduate degree. It could be a certificate or some type of advanced license. Some common examples, as you can see here, are lawyers, doctors, pharmacists, but also other types of professions that you might not necessarily think about, like chefs who've gone to a culinary institute. A word of caution about lawyers, though, as probably we can put that quote up on a board somewhere, probably. But as a lot of you probably know, a lot of lawyers, after they practice law for a number of years, they work in some other type of capacity, especially in the nonprofit world. A lot of the nonprofits here in the room probably employ lawyers who aren't necessarily practicing law. And so you want to be careful there, because if the lawyer's not practicing law for your institution, well, then they might not be exempt under this learned professional exemption, because they're no longer, their primary duty doesn't require work that they needed their law degree for. They might still be exempt under a different exemption, but the learned professional exemption might not be the exemption for that particular employee. Now, the other subset of exemptions under the professional exemption is the creative professional. And the types of employees here, their primary duty, it really must be in a field of artistic or creative endeavor. And what we're talking about are musicians, writers, actors, maybe even graphic designers, people who are responsible for designing your website or marketing materials in some cases. Even a cartoonist has been recognized by some courts as exempt under the creative professional exemption. Journalists are a good example, even though many of the nonprofits listening in and here in the room might not employ journalists. They're a good example because of the distinction between routine work that is non-exempt and creative or artistic work that is exempt under this exemption. So a journalist, the question would be for them is, are they merely collecting and gathering information that's available in the public domain and then just distributing it back to the public in some type of news forum? That would be non-exempt work, because it's that routine mental or manual work. But if a journalist was taking information, gathering it, and then distributing it with their own unique interpretation or analysis, that could be exempt work under the creative professional exemption. Take an op-ed writer, for example. Yes, we have a question.
Quick question. I just want to double check and confirm this. A lot of people are going to college these days and they're getting a Bachelor of Arts or Science. Does that put them in the professional thing if it's just that BA or BS?
So the question from the audience here was, given the prevalence of so many people going to college, earning a bachelor's degree, would that put them under the scope of the creative professional exemption? Right. And it's
yeah, so you're talking about just the general professional exemption for learned professionals.
Oh, for the learned professional exemption. And as with anything, it's a case-by-case analysis. The answer, as more and more people go to college, is that it's less and less likely that they're going to fall under the learned professional exemption, because it's no longer a prolonged course of study that differentiates them from your other employees. But depending on the degree that they obtain, depending on their area of so-called expertise, if you will. It's going to be a case-by-case analysis. And you also want to make sure that the degree they obtained is related to what they're doing for your nonprofit.
And Dan, I know you have a comment. Let me kind of pose a follow-up question, and you can try to tackle it with your comment. Someone from the webinar asked if someone goes to school and gets a graduate degree in nonprofit management, and there are some graduate programs out there in nonprofit management, generally 1 or 2 year programs, you can get some kind of an advanced degree, maybe a master's, maybe something less than that in nonprofit management. Does that, and you're working in nonprofit management as an executive, does that give you a more colorable argument that you're a learned professional under that exemption?
Yeah, I would say that would help a lot, but that to the extent you're in management, that spills over to the administrative exemption. So I would wonder which one you would probably qualify for the administrative as well.
And the executive exemption too.
Yeah. True. And under the learned professional exemption, if you just had a BA or a BS, whether or not that's prolonged enough, as Nick said, is a case by case. But the one thing that's important is that the word usually acquired through prolonged specialized study means that you don't actually have to have done the long years of school. If you've just done a basic BA, or even if you haven't gone to any college, if you're doing the work that is customarily only done by people who've done this long studying, then you could still qualify for the professional exemption.
You have a question here.
We hire an attorney in salary but part-time. How is that?
Well, one question first is so the question is, we hire a part-time attorney who's on a salary basis. You're asking would he qualify under the learned professional exemption? One follow-up question though is he actually practicing law and giving legal advice? And for instance, do you have malpractice insurance coverage for him? All the things that would be in indicia of a practicing lawyer, even in-house.
Well, he is practicing. He's giving legal policy advice. He's no longer barred. He's retired.
Yeah, that's what I thought. Her answer to my question was he's no longer a member of the bar in good standing. He's kind of a retired lawyer who's in the policy area and using his legal background, but not functioning as a lawyer. And that's a big distinction, and that's what these guys were getting at earlier. And that's not likely going to fit within this learned professional exemption. And that is something, of course, that we find very commonly in the nonprofit community. All right, let's move on. Oh, actually, I do have one more question that is probably pretty widely applicable. Well, you know what? This is more a question for employees of CPA firms, and I don't think we have a lot of those here in the room, so I'll address that one offline. Why don't you guys continue?
So the next exemption that we want to discuss, and I should say that the 3 exemptions we've discussed so far, the executive, the administrative, and professional exemptions, are the most common that we see in the nonprofit context. But there's 3 other exemptions we want to touch on quickly before we get to the pitfalls, because we're especially seeing them more prevalent nowadays, and the first of which is the computer professional exemption. These are really your computer programmers, your computer software engineers, systems analysts even. And the first test, as Dan touched on during the overview, is the primary duty test. And for the computer professionals exemption, the primary duty has to consist of one of the 3 following job functions, or at least a combination thereof. The first of which is the application of systems analysis to determine and diagnose IT problems and the needed specifications. The second is the design or testing or creation of computer systems or programs. And the third is the design, testing, or creation of computer programs for machine-operated systems. And again, the primary duty could be a combination of any of those 3 job functions. But this is not, just a word of caution again, this is not your run-of-the-mill IT help desk personnel, the employee who you call up and helps you unfreeze your Microsoft Outlook this is not the while as helpful as that employee may be for you that day, this is not the exemption that captures that type of worker. That worker is, unless subject to another exemption, is likely non-exempt from the Fair Labor Standards Act. And we know this because just about a year ago, Congress tried to push through an amendment to the Fair Labor Standards Act. Republicans and Democrats co-sponsored a bill called the Computer Professionals Update Act. And if that is ever enacted, that would expand the computer professional exemption to include really, arguably, any employee that's working in IT and with computer systems. It was introduced in late of 2011. It was read twice and referred back to committee, and there hasn't really been a lot of legislative traction on it since. And I can tell you there's heavy opposition from pro-labor groups, especially IT unions or other trade associations, because it would be a very big expansion of the computer professional exemption under the Fair Labor Standards Act. And what it really tells us, just the very fact that Congress is trying to push through an amendment, or at least some members of Congress, is that as it's presently written, this exemption in the FLSA, it really contemplates those high-level employees who share a lot of responsibility for creating or making changes to your IT or computer network systems. People like a chief technology officer would be a good example of someone who likely fits under this exemption. I do want to point out, before we move on to the next exemption, that the salary test for the computer professional exemption is a little different. You still have that $455 per week on a salary basis to qualify, but it also allows for hourly paid employees to be exempt. And if they are paid hourly, they have to earn at least $27.63 or more per hour. The next exemption that we want to discuss is the seasonal employee exemption. And this is really a unique exemption than any of the other exemptions that we've discussed because there's no primary duty test. The inquiry is employer specific. And what that means is that if you are exempt, if your business enterprise really, or the business establishment I should say, for the employer, if it meets the requirements for this exemption, then all of the employees that work at that establishment will be exempt from the FLSA. And it applies to three categories of establishments. There's amusement or recreational establishments, there's organized camps, or alternatively it could be a religious or nonprofit educational conference center. And if your establishment falls into any three of those categories, the next inquiry is whether the establishment is really seasonal. And under the FLSA, the establishment will be considered seasonal if it's either in operation for 7 months or less out of any calendar year, or if it's an operation more than 7 months, then the question is whether during the preceding calendar year, if the average monthly receipts for any 6-month period were either a third or less than the average monthly receipts for the other 6 months during that year. So a good example would be a nonprofit that runs maybe an organized camp up in Maine, let's say, and so during the summer months they have a lot more traffic coming through, their receipts are a lot higher. And if you were and you can take any 6 months, it's in the statute, so you can kind of pick and choose which are your highest grossing months and your lowest grossing months. And take this hypothetical for the camp up in Maine, if you were to look at May to October and they're bringing in a lot more revenue there, so long as the average monthly receipts for that 6-month period is high enough so that the average monthly receipts for the other 6-month period is less than a third of that, then all of the employees under that business establishment are going to be considered exempt under the seasonal employee exemption. The last exemption that we want to discuss is the highly compensated employees exemption, and it's relatively straightforward. It basically creates a bright line rule for employees who are making $100,000 or more per year, and that compensation doesn't just include salary, it can include other remuneration to the employee, but they do have to be making at least $455 a week on a salary basis. And their primary duty must be office or non-manual work and they have to customarily or regularly be performing at least one of the duties from the first three exemptions we discussed, the executive, administrative, and professional exemptions. And really the reason for this is that the Fair Labor Standards Act, when it was enacted, it was intended and still is intended to protect the compensation owed to lower income employees. And by creating this exemption, Congress has basically said that we're not setting out to protect the compensation for anyone making $100,000 or more. Yes, we have a question.
Is the annual compensation amount of $100,000, is that adjusted for inflation periodically?
The question from our audience was whether the $100,000 limit for the highly compensated employees exemption is adjusted periodically for inflation. And off the top of my head, I don't know the last time that the FLSA was amended. I don't think it's been recently, certainly. But from a legislative standpoint, it's not out of the ordinary to think that it will be revisited eventually.
But I think what she's also asking, is that something that gets adjusted by the Department of Labor every year, indexed to inflation or anything? Is it? And my understanding is it's a flat amount that's set by statute, and it's like a lot of limits that are set by statute. Like for instance, the limitation on lobbying expenses by 501c3 organizations that make the 501h election. That global cap of $1 million on lobbying expenses has been in place since I think 1976, since 501h was enacted, and that's never been changed or increased, and that's unfortunately the way that it is. Let's then move on.
Yeah, that concludes our portion on the common exemptions for nonprofits. I'm going to hand it back over to Dan. He's going to talk about some of the salary test deductions that can cause problems.
So you've heard over and over that $455 per week, and that's the easy rule that you can set ahead of time, and then you think you're in the clear, but you're not, because the main litigation or controversy over salary tests in the area of deductions, and whether or not you are truly treating your exempt employee as someone who is paid on a salary basis. So there are deductions you're not allowed to do, and there are deductions you are allowed to do, and it's important to get those straight so you don't make any costly deductions. Some permissible deductions from salary are absences for personal reasons, not sickness or disability, deductions for sickness or disability pursuant to a bona fide sick plan. So if they've exhausted their sick leave and they get sick again, then you're allowed to deduct from their salary. You're allowed to deduct for penalties for major safety rule violations and disciplinary suspensions for one or more full work days. And generally speaking, you have to be careful what state you're in, because there are payroll deduction rules that some states do not let you do. So you have to check your particular state before you make deductions. Now, if you do make an impermissible deduction, and let's say you have a practice of deducting an employee's salary when they're late. So if they're 10 minutes late, you take those 10 minutes away. And if you do this a lot, that's a problem, because if there's an actual practice of making improper deductions, then that is going to cause a finding of a misclassification. And now whether or not they find an actual practice, the number of improper deductions, they'll look at that. If it happens sporadically or it happens rarely, then they're not going to find an actual practice. But also the time period of the improper deductions, if it went on for a long period of time, that's bad. And whether or not there's a clearly communicated policy. So you want to make sure that you have a clearly, so what's not okay is if you have a policy that says, like in the handbook, if you are late, you are going to be deducted 5 minutes from your salary. If that's in your handbook, you want to rip that out and get every copy that you've distributed and rip it out there too, because that's a bad sign. Change the policy. Don't have things like that. Now, if there is a finding of an actual practice, then the salary test will not be satisfied for the time period that the actual practice is found to occur. And this is a pretty big rule, but not only does that employee who you made the deductions from, that employee gets retroactively reclassified, but every employee in that person's job classification working for the same managers responsible will also get reclassified. So not just the guy who actually was late every day, but the guy who was on time every day, never got deducted ever. But if he was considered subject to this actual practice, he's going to get reclassified too. But there is something called in the FLSA a safe harbor provision where you're allowed to go back and fix it and say sorry and walk it back. And there's no consequence of improper deductions if, one, you've got to clearly communicate a policy prohibiting improper deductions, including internal complaint procedures, if the employer reimburses the employees for improper deductions, and if the employer makes a good faith commitment towards future compliance, like I'll never do it again. But there will be no safe harbor available if the employer willfully makes improper deduction after they're told about it. So if you keep doing it, you can't say sorry. You can say sorry once, and you can save the exemption.
And Dan, before we move on, we have a question from the webinar that I think will be a good way to illustrate some of the things you just talked about in the salary deduction issues. So this question, I'm going to rephrase a little bit. Person is presumably subject to one of the FLSA exemptions, and the person is paid a salary, but for hours worked over 40 in a week, the person is paid not overtime but straight time on whatever his or her hourly rate would otherwise be for those hours worked over 40. And the question is, would that defeat the salary test? I think that's a pretty easy one, but I'll let you guys answer.
Well, I'll let Nick address that because that's one of the pitfalls that we're going to talk about, and I know about whether or not you pay an exempt employee extra be beyond the salary.
Yeah, we're going to address that in the pitfalls. I don't know if you want to hold on.
Okay. We can wait till later.
Okay, so moving on to independent contractors. This is a completely different topic, shifting gears entirely. Nothing to do with duties, nothing to do with salary. In fact, they're not even employees, right? They're independent contractors. But it is very, very important because this is the second biggest issue for employers is trying to, what I call cheat, and it's easier if you have independent contractors because you don't have to worry about all the tax withholding, you don't have to worry about things like that. So you're able just to call an independent contractor and be done with it, right? But it can be severe consequences if you misclassify them. So there are a lot of factors, and I'm just going to jump straight to the main test that's used. There's a basic three-prong test, and the three-prong tests are, first, financial control. They'll look at factors like whether or not there are unreimbursed business expenses, whether or not the worker's investment in the facilities or tools used in services. The second major prong is behavioral control, right to direct and control what work is accomplished, how the work is done. The basic rule of thumb is if you're telling the worker what to do, then that's an employee. If you're training the worker, that's an employee. Independent contractors are truly independent. They are people who you hire to do something for your enterprise that you don't have employees do. You engage them. And the last prong is the type of relationship, and this has to do with whether or not the parties truly subjectively consider themselves to be governed by an independent contractor. And I'm just going through these quickly because I think that the 20-factor test is really captures all this well, and I have animation for this, so I'm happy. So the first factor is level of instruction. Like I said, this has to do with how much the employer says do A, B, and C, and that's bad. That is not an independent contractor. Second is the amount of training, how much training the person goes through before starting. Independent contractors are trained themselves. An employer doesn't tell them how to do their job. They know it themselves. That's why they're independent. The third is degree of business integration. This has to do with whether or not the independent contractor truly comes from a separate entity, or does the independent contractor do things for the employer that the employer does himself? So if you do things like education and you bring on an independent contractor to to do more teaching for the same kinds of classes, then that's not an independent contractor. If it's your business, that's not independent. So these three things, by the way, the first three of the 20, these are the most important guidelines that the IRS uses. These three are the ones that the IRS looks at the most, considers the most important. But just to run through the others, the fourth one is the extent of personal services, to the extent that the employer demands that somebody in particular do the job, that suggests it's an employee. Usually you just call the plumber, right? And you say, I need somebody to come, and they send somebody. You don't say, I want this guy to come. That's more of an employee relationship. Whether or not they control assistants. If the independent contractor, if the worker controls assistants who work for them, that's considered an independent contractor. Employees usually don't have assistants. The continuity of relationship is very important as well. Is this a long-term relationship? If the person works full-time and the person is there for years, that's usually not an independent contractor. The flexibility of schedule. Independent contractors usually set their own schedule. Employees are told when to start working. The demands for full-time work, again, employees are full-time, independent contractors are not. The need for on-site services. Employers say, come to my place, do your work here. Independent contractors are usually allowed to work from their own facilities. Sequence of work, employer controls what the order the work is done in. Independent contractors decide themselves. Requirements for reports. The employee has to give reports and update their boss. Independent contractors don't have to report to them. Method of payment, whether it's a paycheck every 2 weeks, that's a bad sign for an independent contractor. It's probably not going to be right. Payment of expenses, independent contractors pay their own expenses. Provision of tools and materials, independent contractors have their own tools. They invest in their own facilities. They have their own place. They don't work out of the employer's place usually. Realization of profit or loss, this is a big one. Can the person lose money? Are they taking risk in what they're doing? If they're taking risk, they're not an employee, or usually not an employee. If they're not taking risk, that suggests they're an employee. Working for multiple companies, that's important because independent contractors hold themselves out as available to the general public. Independent contractors advertise, and multiple companies will call them and say, work for us, and they will do that. An employee usually has one boss. They go to one person's place of employment, and that's a sign of that. Control over discharge and right of termination. This has to do with the fact that employees are usually at will. Independent contractors tend to have more contracts, and they're more long-term. And those are the basic ways to look at independent contractors. This will help you. It's a very tricky issue. It's a very severe consequence for misclassifying. But if you look at these things, you might start to get an idea. You might start to wonder in the back of your mind, oh my God, what have I been doing with this independent contractor, or this person I thought was an independent contractor? And so if you start to wonder and worry by looking at these factors, you should definitely take a close look at it, call one of us, and we can certainly help you with that.
Just a couple comments, Dan. This is obviously a huge area in and of itself. We actually devoted a whole webinar to this back in May 2011. The recording's on our website if you want to listen to that. Quite an interesting and complex discussion. But we felt it was important to touch on it here today, in that, if you are it's hard to find a nonprofit organization, at least a decent-sized nonprofit organization, that's not misclassifying some of its folks as exempt versus non-exempt, employees versus independent contractors. I'm sure you guys agree that we've never done an FLSA audit or an independent contractor audit where we haven't found at least some instances of likely misclassification. And sometimes you don't know for sure because it's clearly not black and white. But if you have misclassified an employee as an independent contractor and then they get properly classified as an employee, particularly if they're deemed to be a non-exempt employee, then you have to deal with everything else that we talked about going back sometimes several years. So it can have some very significant consequences. So if you're going to be kind of looking under the hood and checking out and doing your own internal self-audit or bringing in an outside help to do an FLSA audit, an exempt versus non-exempt classification, be sure you also cover employee versus independent contractor exemption as well. And before I forget, I mentioned earlier at the beginning that there's some good resources, articles in your handout materials, two in particular that are directly relevant to this. One is called Top 10 Compensable time issues for non-exempt employees of nonprofits, and then the other is kind of a companion piece. It's really a chart that gives a lot of different common examples and where nonprofits typically get tripped up. I would definitely encourage you to take a look at those. And now let's move on to the final and I think most interesting part of our presentation today, the top 10 most common classification pitfalls for nonprofits.
Thanks, Jeff. So as Jeff just said, now we're going to actually tackle some of the common pitfalls, specific pitfalls that we see, really the rumors that Dan was talking about earlier, and I'm just clicking through them here so we can jump into them. But as you see them pop up on the screen or on your slide, what you can really see from all of them, the commonality here is that there's some myth out there for each one where employers often think that a group of employees are necessarily exempt, or per se exempt, because of just one characteristic about them. And that actually segues a little nicely into the first pitfall we're going to talk about, which is where nonprofits think that all of their salaried employees are necessarily exempt. And I can't tell you how many times, especially with new clients that were founded relatively recently or haven't been getting a lot of legal advice or just wrong legal advice beforehand and then are referred to us, they say to us, oh, well, those employees don't get overtime, they're salaried employees. And that's one of the biggest myths we see, because remember, as we were saying earlier, the salary test, that's just half the equation. And it's really not even the most tricky part of the equation. It's just the $4.55 per week usually. You really need to take a hard look at the primary duties and to see if the primary duty test is met before you can consider that employee exempt. And salaried employees can be entitled to overtime. And it's even trickier sometimes to do the calculation. What you want to do is you want to determine the weekly salary. We'll take round numbers as a hypothetical. If someone's making $52,000 a year, or another way of saying it, $1,000 a week, and they're working a 40-hour work week, well, then you would divide the $1,000 per week by 40 for an hourly rate of $25 an hour, and then everything that they're working beyond 40 hours in that work week, they're going to be entitled to a premium of $12.50 on top of that $25 an hour that they make. And you can see here at the bottom of this slide, we have special rules for the fluctuating work week. I don't know how many of the nonprofits in the room or listening in use a fluctuating work week. It's not permissible in every state, so I should caution you that you want to consult legal counsel before you decide to use a fluctuating work week. California, for example, where Dan's from, does not allow that. Pennsylvania recently, a federal court said that the fluctuating work week pay plan is violative of the Pennsylvania Minimum Wage Act. So you want to make sure you have compliance with your state corresponding labor law too. And we're happy to talk more about the fluctuating work week afterwards, but I know we want to get to some of the other pitfalls.
So the second pitfall, and it's kind of similar to the first one in that always classifying blank as exempt, so always classifying salaried people as exempt, and this is the second, a large universal myth that's wrong, always classifying supervisors as exempt. And Nick talked a lot about the executive exemption and what exactly it means, the primary duties. And what happens a lot of times, and I've had a lot of cases where the company has a supervisor, and the supervisor is kind of a supervisor in name only. Sure, they might be the one in charge because the boss is gone, but they're pretty much doing hourly work. Like we say, like they're on the line. They're with the people they're supervising. So they're like a lead foreman. So if the supervisor, in quotes, has 5 employees, they're working with the 5 employees as the 6th person doing everything that they do. And if that's what they're doing, then they're not exempt. They really have to spend, as Nick was saying, their primary duty has to be the type of management work. Walking the floor is a great way that you want your supervisors to spend time, just walking around, looking at what their people are doing. So if there are people are opening envelopes in some kind of boiler room and mailing things, then that supervisor can't be sitting next to them for the whole day doing that same thing. Now, sure, they can jump in and help when you're short or when they're on break, but their primary duty has to be managing those people, has to be walking around, doing reviews, things like that, directing work. That is the key to whether or not that person is exempt. So just because the person is in charge, just because the person has a name tag that says shift supervisor, doesn't mean that they're exempt. Even if they have the power to basically direct work and they're the ones in charge, it's not going to be not going to qualify for the exemption.
Pitfall number 3 is when employers make classification decisions based upon job descriptions or titles only. And as Dan pointed out earlier, job descriptions are critical, but where employers have classification errors based upon job descriptions, it really highlights the need for regularly conducting internal audits, because very often an employee will take on more job duties than his or her job title or job description calls for. There might be an employee who was fired, and so an employee who stayed on with the company may be presumed that terminated employees' job functions, or it might just be merely the growth of your nonprofit. It might require that an employee's job duties evolve over time. Conversely, an employee, especially as a nonprofit grows and as the employee gets promoted, he or she might delegate some of his non-exempt or exempt tasks, and they're no longer under that same classification. So job descriptions are really helpful, but a court or an agency like the Department of Labor, they're really going to want to get into the meat and potatoes of it and see what the employee is actually doing on a day-to-day basis, and that's what they're going to use, not the job description necessarily, to determine whether the employee is properly classified. I want to point out also that job descriptions are very important for disciplinary issues. If an employee is straying from his or her written job description, the employer should approach that employee, and you should document it in the personnel file that you've had a discussion, that you've warned the employee that it's very important that he or she sticks to the written job description. And this can be very helpful if unfortunately you have a penalty assessed against you. Under the Fair Labor Standards Act, there's 100% liquidated damages for overtime wages that are owed if it's a willful or a reckless violation of the statute. And I know in my home state in New York, it's another 100% under the New York labor law if it's a willful or reckless violation. And there used to be a split in the federal courts, and now more and more federal judges are allowing successful plaintiffs to double dip and essentially get 200% liquidated damages. So even if the overtime wages that are owed and back pay are relatively minor, they can quickly escalate with these damages. If you have this written job description, and if you've been documenting in the personnel file that you've been approaching your employee, explaining to him or her, hey, you really need to stick to your written job description, don't go doing these other job functions, that will go a long way towards showing that you were not willfully or recklessly misclassifying this employee as exempt.
Nick, before we move on, I have a question from the webinar. So under this rule, are exempt employees required to take an entire day of leave, say if they leave the office for a 2.5-hour doctor appointment, or are they allowed to just take 2.5 hours of, say, paid time off leave? Without violating, assuming we're talking about exempt employees, without violating the salary deduction prohibition that we've been talking about. For exempt employees, what's the basic ground rules about when they want to take partial days off? Do they have to take a full day's leave? Do they take no leave? Can they use 3 hours worth of leave, et cetera?
Yeah, and I'll actually, that's actually pitfall number 4 that we can jump right into, and that's making deductions.
Sorry, I was looking at your screen, Dan. Not this one. My fault.
That's okay. No, making deductions from exempt employees' paychecks, and the general rule is that, as we said before, they must get a guaranteed base salary. So whether it's $455 per week or it's something more, that must be the level they cannot fall below unless they're there's a permissible reason for the deduction. So if the person, to the question, if the person goes out on some kind of doctor's appointment for 2.5 hours, then you have to pay them for the whole day. You're not allowed to deduct from their salary, generally speaking. Now if they can take the whole day if they want to, and that's the problem with the deduction is that they're allowed to take the whole day for that. And then if you have a sick bank, if you have some kind of sick leave, you're allowed to deduct it. But the general rule is if they come late or they leave early, you have to pay them that guaranteed base salary. Sometimes the reasons for them being late or leaving early doesn't even matter. If they come half hour late because they overslept, doesn't make you any more able to deduct than if they came half hour late because they were helping a cat in a tree. It doesn't matter what the reason is. If they're late, you have to pay them their full amount.
But just to double back to my question, though, in terms of leave deductions, say a lot of nonprofits have paid time off, so it's sick leave, vacation leave, it's all rolled into one. I'll give you some examples. A lot of our clients have, say, a 7.5-hour workday, and their policies say that as long as an employee, and we're talking about exempt employee, works for 5 hours, then even if they're taking 2.5 hours off for a doctor's appointment, they don't have to use any leave for that. But that if they work less than 5 hours in that given day, then they have to use paid time off. They have to use their leave bank. They have to use 3 hours of leave or 4 hours of leave, and then they're working the rest of it. Does that in itself run the risk of violating the salary test?
No, it does not. That is permissible under the FLSA. You are allowed to deduct from leave banks to make up the difference. So if someone comes in an hour late, you can say, okay, we're going to take that out of your PTO. So that's okay. Now there are wages, and so you're not exactly saving money. You're still paying them their full wages, but at least you're kind of saving by taking out of their leave banks. Now
the follow-up question, and I know the answer to both, but I want to make sure everyone understands this. What if someone's out of PTO and they've used up, they accrue PTO, but they just took their big vacation at the beginning of the year. They really don't have enough. Salaried employee, exempt employee taking that 3-hour doctor appointment, but they're out of PTO. Is there any recourse for the employer, or do you just have to let the person take the time off and not do anything about it? Or can you have like a negative deduction in the leave bank that they make up later?
That's a good idea. I mean, certainly advancing them a vacation or PTO is a good idea, but the unfortunate thing is that you are basically stuck paying them their full salary. Now you're allowed to discipline them. That's obviously a key thing that employers have the ability to do. You're not at the mercy of this employee who just thinks he can do whatever he wants. He can come in late, he can, leave early, and he's like, I'm exempt, you have to pay me. But no, you can discipline them. You could either fire them, suspend them. You could do a lot of things that, because you're allowed to keep their hours. That's one myth that's not in here, but that's certainly another myth. You are allowed to require an exempt employee to keep certain hours, to come at certain times, not leave till certain times. And although you have to pay them according to other rules, you're able to discipline them and deal with them through other methods besides salary deductions. You just can't deduct from their salary. That's the no-no here.
And of course, one more, it's not related to exempt employees, but related to non-exempt employees. You're also allowed to manage, and correct me if I'm wrong or if I'm missing any part of this, you're also allowed to manage the hours of non-exempt employees. So while you certainly have to compensate them for all time worked over 40 hours in a given week with arguably this little exemption, which I don't know if you want to get into, for paying comp time at time and a half if it's within the same pay period. But with that aside, the basic rule is you have to pay them for every hour over 40 worked in a week, but you can not allow them to work more than 40 hours. So if, for instance, you're at the trade association's conference and the non-exempt employees are working 12-hour days for 3 days in a row, and you get back to D.C., you can require them to basically not work the rest of the week so that they don't go over that 40-hour mark.
Right, and that gets into the issue of suffered or permitted. Like you can say do not work, but if they come in anyway and try to work like secretly, you have to pay them for that work usually. I mean, you could say that we didn't know, we didn't authorize it, but the better rule is if they're working unauthorized work, pay them, but then fire them and say, hope you had a good morning.
or pay them and then discipline them. And the same rule, and we see this all the time, where non-exempt employees who come in early because they're part of a carpool, or their train or their bus gets them in early, or they stay late because they're waiting for someone to pick them up. And even if they're sitting at their desk and reading the newspaper or surfing the web, if you are allowing them to be there at the office, even if you don't think they're working, they're not asking to work, they're viewing it as just hanging out and waiting for the ride. If you are, like Dan said, suffering or permitting them to be there, then later, when that disgruntled employee does get fired because he or she messed up one too many times, and they go consult a labor lawyer, and then they figure out what kind of claims they can bring against the nonprofit organization, you may find yourself stuck with paying all sorts of back wages going back several years.
Yeah, I mean, it depends the timekeeping system you have. If you have a punch card, then usually if they punch out, then go back to their desk, they'll call that off-the-clock time, and that can have a big effect. There are a lot of off-the-clock class actions where employees claim that, well, I worked before my shift, I worked after my shift, but I was made to clock in and out at my shift start time. So the worst kind of case, because the employer doesn't know about this alleged work, but yet they argue, you allowed it, you benefited from it, and my supervisor told me I had to do it. So that's certainly a problem there, but you are allowed to regulate that.
And of course, finally, the same issue goes for non-exempt employees working from home. With the ease of working technologically, it's very easy for non-exempt employees to work from home, which is one reason why a lot of nonprofits do not allow their non-exempt employees to have access to the organization's network from home, and they don't allow them to have a BlackBerry and iPhone that has access to their work emails and things like that, and they're actually prohibited from doing any work off hours, with the exception of if they get express permission from their supervisor. But it's the same thing. If you are allowing this to happen, even if you're not asking them to do it, and then later the disgruntled employee files a lawsuit, brings a complaint with the EEOC, goes to their state, the state labor enforcement agency. In any of these situations, there's lots of ways that these claims can come up, and they often come up later when one or more disgruntled employees is making the storm and posting things on Facebook, and then other former employees say, hey, wait, that used to happen to me, and I want to join in with you. We're going to file a joint complaint, and we're going to go after these guys for all these back wages. It happens all the time, and that's why you really need to be vigilant in regulating the work and the work hours of your non-exempt employees. You had a question there?
Yeah. Going back to the case of the person who had a long commute and maybe typically in the office, not during work hours, is it better for the employer to have them say their job is 9 to 5, have them Starbucks until 9, versus coming in at 8 and reading the newspaper and getting the employer into an awkward situation?
And this really everything that everybody's saying, and I should say the question from the audience for everybody listening online was, what about the employee who's traveling in and might get to work half an hour early? Should they go sit at Starbucks across the street until their shift starts at 9 o'clock? And this really highlights the importance for clearly defined policies in your employee handbook. You want to put all your employees on notice that it's not okay to come in at 8 o'clock an hour before and to hang around until your shift starts at 9. And the reason for that is because that is going to lend itself to off-the-clock work being performed. And you might even have employees later trying to say, well, I should be able to leave early now because today I got in at 8 in the morning. But that doesn't mean that they need to wait at Starbucks until 8:59 and then come across the street. You can put in, we see clients with perfectly permissible employee handbooks that say, that give grace periods around 15 minutes, 20 minutes, maybe 5 minutes, that they pick a time period for when employees can come before to work, but they make clear in their handbook that they're not to begin work until their shift begins. And it's usually not enough just to put in your handbook. You really got to police the policies in the handbook too. And then some employers go a step further and they have designated waiting areas at their work site, an employee lounge, a cafeteria, things like that. So a clearly defined policy, though, is paramount when you're defending yourself against an allegation of off-the-clock work.
Sorry to take us all offline there. We weren't going to cover all of those details in the pitfalls, but I know those are questions that we commonly get. And some of those materials I referenced earlier have further discussion of these topics in there. Actually, we're going to need to move on to the other pitfalls to make sure we end on time, but we'll stick around later for more questions.
So the next pitfall, pitfall number 5, and I think we had a question from our online audience about this earlier, is the misperception. It might sound a little funny what I'm about to say, but it's the misperception amongst employers, nonprofits alike, that exempt employees can't receive anything above and beyond their weekly salaries. And I say it might sound funny because why would an employer fret about paying their employees more money? But you'd be surprised that we get a lot of inquiries about, from employers saying, well, I know they get a weekly salary, and I know we conducted that audit way back when, and they're properly classified. But if I give them a commission on some big account they brought in, or if I reward them for their great quality of work recently, is that somehow going to transform them from exempt to non-exempt? And the answer is no. They're going to remain exempt so long as they will meet the duty test, of course, but so long as they keep getting that guaranteed base salary that's above the salary test threshold. As long as that base salary is paid, you can reward employees with additional compensation. And examples we see are, for sales figures, productivity levels, the work performance, but also some employers, even though their employees are exempt, they want to reward their employees for lack of a better phrase, for overtime work. They're not entitled. The employees are exempt, so they're not entitled to overtime wages. But when an employer knows that their employees have been burning the midnight oil for a long time, they want to reward them. And sometimes it's just good business, especially from a recruiting standpoint.
Pitfall number 6 is classifying all employees who work with computers as computer professionals, and Nick covered this very, very well and exhaustively. This is the basic misperception that just because, as Nick said, somebody comes to unfreeze your Outlook, that makes them exempt because he works with computers. And frankly, I understand why, because all the gobbledygook about why someone's exempt computer professional, to me, I don't understand it. It's all about what software and hardware and things like that, and it's hard to understand. So a lot of times employers see an employee who's working with computers and just says, okay, that person's exempt because they're a computer professional. But it's very, very complicated, very, very intricate rules over whether or not the type of work they're doing is exempt, and has to do with making things and developing models and developing software, not just troubleshooting. Employees may perform highly technical tasks, but be at another complete direction. Computer professional exemptions more likely to become stale over time for specific employees, and that's because as the technology moves, sometimes the employees will begin to follow a playbook. And if the person has a step 1, step 2, step 3 approach to problems or to their job, then they're probably not exempt. So be wary of when you use the computer professional exemption to make sure that the computer people are doing what they're supposed to.
Pitfall number 7 is necessarily classifying your commissioned employees as exempt. And we see this a lot because employers say, oh, this employee really only gets paid based upon what they bring in for our enterprise. So they're not entitled to overtime, right? And the answer is it depends, because there's some clearly defined exemptions from the Fair Labor Standards Act, but those requirements still need to be met. And the most typical employees who are commissioned who will be exempt are either outside salespersons or commissioned salespersons. Your outside salesperson, again, it gets back to that duty test. Their primary duty has to be the making of sales or obtaining orders or contracts either for services or for the use of facilities. And provided that they do that's their primary duty, the location is a factor. They have to customarily be engaged away from the business establishment to perform those exempt sales duties. And customarily means more than occasional, but less than constant. And it's typically at least every work week. And by being away from the business establishment, what courts or the Department of Labor is going to want to see, they're going to want to see the employee going to the customer's place of business or the customer's home. They don't want to see the employee at a fixed location. Even if the location is the employee's home, even if the employee is at their own residence performing these sales functions, that's not going to be enough. That's going to be perceived as an extension of the employer's business establishment. So you really want to think about the traveling salesperson with a suitcase and lots of stickers on it going around as the type of person who's going to be exempt under the outside salesperson exemption. The other common exemption for commissioned employees, but that's commonly misclassified, is the commissioned salesperson. And those are employees who work for a retail or a service establishment whose rate of pay is above 1.5 times the minimum wage. And that doesn't just include salary, that's all earnings. And half of their earnings, though, have to be in the form of commissions to be determined a commissioned salesperson. And by retail or service establishment, that's where a lot of employers get hung up on. The Department of Labor has said that means that 75% or more of the employer's dollar volume has to be in the form of goods or services that are not for resale. In other words, that go to the customer, and that's the final destination for those goods or services.
Pitfall 8 is equating all jobs performed by highly educated employees as exempt jobs, and this is similar to the computer professional pitfall, and that's, oh, that guy's really smart. That guy went to graduate school for a long time, so he must be exempt. Almost like you don't understand what he's doing, so therefore you're just not going to even get into it and call him exempt. And that's misleading because there are some jobs that require special degrees or prolonged course of study, but the problem is there's still the two main red flags are they're not using independent judgment and discretion, and they're following prescribed procedures. And if that's happening, even if it's complicated, even if no one understands it, even if you have no idea how to do the job, if the person left, you still can't classify them as exempt. So you have to be wary of such situations.
Pitfall number 9 is, we have it described as the myth about independent contractors. And really, all independent contractors are probably not independent contractors. And employers almost reach for it. Think of it as like a scientist trying to prove their hypothesis. And the reason for that is because everything's easy if the worker is an independent contractor. They're exempt from the FLSA. There's no workers' comp insurance that needs to be acquired. They don't have to get any benefits usually. Everything's just nice and clean if we can just classify this worker as an independent contractor. And a lot of the times when we start to review the factors, we find the misclassifications really under the same factors that Dan described, but kind of the real high-level factors to consider. The first thing I can tell you that a Department of Labor investigator asks over the phone during that first conversation when we've received a notice of a possible violation is, does this independent contractor perform the same functions as any of your regular employees? And if the answer is yes, that's almost dispositive, I can tell you right now. And the reason is because a court or the Department of Labor or any other state or federal agency, they look at that as the employer trying to circumvent all of the requirements that go along with employing someone, the taxes, the benefits, the insurance payments that need to be made. And they really look down upon it, and they're not going to let you go if that's the case. So that's arguably at least the most important factor. Other really high-level factors are whether I call it the ends versus the means. The employer gets to determine the objective, but the independent contractor should have a lot of discretion for the means to achieve that objective. Other things high-level factors, and Dan touched upon it, is the availability of the worker's services. Can the worker offer his or her services to other possible clients? If so, that's a strong indicator that the worker is properly classified as an independent contractor. And lastly, are the worker's services integral to the business enterprise? If so, the worker's probably an employee. But if the worker's services, and that's not to say that the worker's services can't still be unique in some way, but they really shouldn't affect the business enterprise's so-called bottom line.
And Nick, just 2 points to add on to that. One thing we see very commonly in the nonprofit world is a former employee or someone who has been employed by the organization moves to another state for whatever reason. Husband got a new job, moving with the husband. The organization says, hey, why don't we keep you on as an independent contractor to work part-time for us, but essentially doing the same function you were doing before, just on a part-time basis out of a home office in, say, Colorado. What's wrong with that as an independent contractor? This happens all the time. But the reality is, in that situation, particularly where that person is not performing similar services for other organizations, and of course there are other factors too, like are you doing the exact same job you were doing before? That's not a helpful fact. But especially if you're not performing similar services for other nonprofits or other organizations, then that person is probably misclassified as an independent contractor. But if that person has business cards, they have a website, they have other clients, or at least they're making an active effort to get other clients, that can be a helpful fact. The other thing to keep in mind that is with the independent contractor issue, you have another very large and important federal agency that comes into play to enforce these rules, and that's the Internal Revenue Service. And we see it all the time, and we see IRS examination of independent contractor versus employee issues come up as compliance checks and audits in their own right, but we also see them evolve from other examinations of tax-exempt status or unrelated business income or lobbying and political activity, and then the examination will be expanded to cover these issues. And the IRS gets very interested in this because there's a lot of employment taxes involved here that the IRS can collect from misclassifications. And so it's very much a potential revenue raiser for the Internal Revenue Service. So you really need to be cognizant of that for that reason as well. And then let's let Dan finish up with pitfall 10 so we can wrap up.
All right, just quickly, the last one is the misconception that if an employee works for any part of the week, an exempt employee must pay them for the entire week. So some people think that they work part of the week, you have to pay them the whole week, but that's not true. If the employee absences himself for full days for personal reasons and they're out of PTO or vacation, then you don't have to pay them for that full day. The only issue is that you can't send people away for a day and say we're not going to pay you for that day. As long as the employee is ready, willing, and able to work on the day, let's say Monday is ready, willing, and able, you can't say go home today, we don't have work for you, and then work them Tuesday through Friday and pay them only Tuesday through Friday. If the employee is ready, willing, and able to work the whole week, then that employee must get paid for that whole week unless you furlough the employee. Companies are able to furlough employees for weeks at a time. So you could tell employees, don't come back next week with no work, and you don't have to pay them for that whole week. But if they start working in a week and they continue to be ready, willing, and able to work for that week, you have to pay them the whole week. Lack of work is not a reason to pay. But sometimes that gets confused and the misconception comes up that if they work part of the week, they have to get paid the whole week, and that's not always true. Because, again, if they're absent themselves for full days for personal reasons, then you can deduct their salary that one day.
And, of course, like we mentioned earlier, for partial day absences, it is absolutely impermissible to dock someone's pay, an exempt employee's pay, for a partial day absence without risking turning them into a non-exempt employee. You can, however, require them to use several hours of paid time off, and if they're out of paid time off, you can advance them that amount and require them to, put that into their leave bank, but you cannot dock their pay for partial day absences. Okay, with that, it's come time to end our program. I want to thank Dan and Nick for coming to D.C. for a great program here today. Thanks to all of you for participating, and we hope to see you back here next month. Thank you very much.